This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about a case where defense was required because the Seventh Circuit Court of Appeal concluded a catch-all exclusion was ambiguous, and that even clear language in a policy of insurance can be ambiguous. After an artificial intelligence company collected facial recognition images in violation of Illinois statutes, the corporation sought defense and indemnity from its insurer. Windalco Enterprises, LLC was sued in two putative class actions for violating the Illinois Biometric Information Privacy Act, or BIPA. Its business liability insurer, Citizens Insurance Company of America, sued, seeking a declaration it has no obligation under the terms of the insurance contract to indemnify Windalco for the BIPA violations or to supply Windalco with a defense. The district court entered judgment on the pleadings for Windalco, finding that the language of the catch-all exclusion relied upon by the insurance company was ambiguous on its face, and that construing that ambiguity in favor of the insured citizens consequently had a duty to defend Windalco. In Citizens Insurance Company of America versus Windalco Enterprises, LLC, a June 15, 2023 decision of the United States Court of Appeal for the Seventh Circuit, the litigation arose from a massive database of facial image scans assembled by Clearview AI, an artificial intelligence firm that specializes in facial recognition software. Clearview AI allegedly extracted in excess of 3 billion photographs of individuals from online social media, converted those images into biometric facial recognition identifiers using proprietary algorithms, collected the original images and their biometric counterparts into its database, and paired those images with information as to where those images were found on the Internet. Clearview AI has also created a facial recognition application or app that allows a user to identify an individual by uploading a photograph of that person to the app. The app then allows the user to see other photographs of the same person on the media platforms or websites where they appear, along with the identifying information, including their name, address, and other personal information associated with that individual. I am probably in that database, and I'm sure my privacy is being affected by the database. Both suits allege that Windalco's role in the transaction ran afoul of BIPA. Illinois became the first state in the nation to enact biometric data privacy litigation when it promulgated BIPA. Broadly speaking, BIPA codifies an individual's right of privacy in and over his or her biometric identifiers and biometric information. At the time of the sale of the Clearview AI app to the Chicago Police Department, Windalco had business owners' insurance coverage through a policy issued to it by Citizens. Section 2 of the policy sets forth the liability coverage for the business. Citizens contends that the coverage of the class action claims is barred by a catch-all provision in the policy, exclusion barring coverage for injuries arising out of certain statutory violations. The catch-all exclusion provided, quote, any other laws, statutes, ordinances, or regulations that address, prohibit, or limit the printing, dissemination, disposal, collecting, recording, sending, transmitting, communicating, or distribution of material or information. Illinois regards the proper interpretation of an insurance policy as a question of law. Policy terms that purport to limit the insurance company's liability are construed in favor of coverage, but only when the terms are ambiguous or susceptible to more than one reasonable interpretation. In some instances, the language of a policy exclusion may appear clear in isolation, but when compared with a separate policy provision granting coverage for the same time of action or injury that the exclusion ostensibly reaches, an ambiguity arises, according to the Seventh Circuit, in that the exclusion appears to take away with one hand coverage that the policy purports to give with the other. Of course, that's exactly what exclusions are for. Regardless, the Seventh Circuit found that because the aim of policy interpretation is to give effect to all provisions of the policy and avoid, whenever possible, construing one provision in a way that tends to nullify another provision, a court, when confronted with such an ambiguity, must consider whether the reach of the swallowing exclusion can be deemed narrower than its plain terms taken in isolation would otherwise suggest. There was no dispute that a literal plain text reading of the catch-all provision would include BIPA violation. The Seventh Circuit noted that the text does not seem particularly ambiguous, quite the opposite. It seems clear as a bell, and the clear message is that the provision sweeps broadly. The text was undoubtedly broad. The Seventh Circuit agreed with Windalco that the catch-all provision of the exclusion, however, is ambiguous, because a plain text reading of that provision would swallow a substantial portion of the coverage that the policy otherwise explicitly purports to provide in defining a covered personal or advertising injury, and arguably all of the coverage for certain categories of wrongs, copyright infringement, etc., to take one example, that are entirely statutory in nature. On a plain text reading, the catch-all provision has an extremely broad sweep, so broad, in fact, that the exclusion on its face would eliminate coverage for a number of statutory injuries expressly included in the definition of personal and advertising injuries that the policy purports to cover. The clash between competing provisions of the policy gives rise to the Seventh Circuit concluding there is an ambiguity in the insurance contract language, and that the catch-all provision was and is intractably ambiguous. Applying a well-established canon, the ambiguity must be construed against citizens and in favor of the insured. As the catch-all provision says nothing about injuries arising from statutes regulating privacy interests, and oral or written publication in any manner of material that violates a person's right of privacy is covered, the Seventh Circuit concluded that the injuries alleged, complaints at least potentially fall within the coverage of the citizen's policy. And since there is such a potential, the Seventh Circuit concluded that citizens thus owed its insured Windalco a duty to defend it against those complaints. In my opinion, exclusions in insurance policies exist to limit the coverages provided by the insuring agreement and cause it to provide less coverage than an unlimited insuring agreement. Since people are entitled to enter into any contract that the insurer is willing to offer and the insured is willing to accept, the court will usually refuse to rewrite the contract to provide coverage that was not purchased. There was no question that the catch-all exclusion was clear and unambiguous, but the district court and the Seventh Circuit found an ambiguity because the exclusion limited the effect of the insuring agreements. In this case, the Seventh Circuit rewrote the policy and provided the insured more coverage than it purchased. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you found this video and blog posting to be useful or interesting, please tell your friends and colleagues about the blog and the videos so that they too can subscribe to the blog and the videos, all of which are available free to anyone who subscribes either to YouTube or to my rumble.com, and I'd appreciate it if you watch the videos, if you click on the like button and or the thumbs up button at rumble.com. And if you wish further detail and excessive information about insurance, insurance law, insurance claims, and insurance fraud, please consider subscribing for a very small fee to my locals community or my Substack publications. Thank you for your attention.